Jefferson County Court at Law Number 2 is now in session. My name is Judge Terrence Holmes. I'm the presiding judge here in County Court at Law Number 2. You have been asked to come to court today because you have a case in this court. The case that you have is a criminal case. Criminal cases are divided into felonies or misdemeanors. If you had a felony case, the felony cases are normally referred to as your most serious type offenses, whereas your misdemeanor cases are referred to as your petty offenses. Does not mean that they're not serious. It just means that they're not as serious as a felony case. And what I mean by serious, I'm talking about the nature of the offense, as well as the punishment range. That is the punishment that you can get if you are convicted of the charge. For example, felony cases are divided into 5 categories. You have the capital murder, first-degree felony, second-degree felony, third-degree felony, and the state jail felony. If you had a state jail felony, the range of punishment is anywhere from 6 months to 2 years in the state jail, a fine up to $10,000. If you're convicted of a third-degree felony, the range of punishment is minimum 2 years to a maximum of 10 years in the state penitentiary and a fine up to $10,000. If you're convicted of a second-degree felony, the range of punishment minimum 2 years to a maximum of 20 years in the state penitentiary, a fine up to $10,000. If you're convicted of a first-degree felony, the minimum punishment is a minimum 5 years to a maximum of 99 years to life, and a fine up to $10,000. Now, if you're convicted of a capital murder, the range of punishment is life in the state penitentiary or death by lethal injection. The case that you have in this court is classified as a misdemeanor. Misdemeanors are divided into 3 categories. You have the Class A misdemeanor, the Class B misdemeanor, and the Class C misdemeanor. If a person is convicted of a Class C misdemeanor, the range of punishment is fine only. Cannot give you any jail time. We only can give you a fine. And the Class C misdemeanors are cases that are normally handled in the JP court or the municipal court. However, they come to this court when a person files an appeal to this court. They get convicted in the JP court or the municipal court, and then they file an appeal, and then the case come up to this court. The range of punishment does not change. It's still by fine only. Now, if you fail to pay the fine or you fail to do community service, if it's converted to community service, then a capious pro fine can be issued. That is a warrant for your arrest. And you would have to either sit out the time or pay the full amount of the fine. Now, if you had a Class B misdemeanor, the range of punishment is minimum 0 days to maximum 180 days, which is 6 months in the county jail, a fine from $0 to $2,000, or you could be given both such fine and confinement. If you are convicted of a Class A misdemeanor, the range of punishment is 0 days to 365 days, which is a year in the county jail, a fine from $0 to $4,000, or you could be given both such fine and confinement. Now, as a defendant in a criminal case, you have rights. And one of the rights that you have is on the clipboard, you have a right to have an attorney. Now, the document that you have on the clipboard, it should be the first page, is titled Judge's Explanation of Rights to Defendants Without Attorney. And in that document, it states that as a defendant in a criminal case, you have 3 options regarding your right to have an attorney. Number 1, you may hire an attorney. Number 2, if you do not have enough money to hire an attorney, you may request that an attorney be appointed to represent you. And number 3, you may represent yourself. Now, if you want an attorney to represent you and you have enough money to hire an attorney, the case will be reset. Reset means you'll be given another court date. It'll be rescheduled. And to give you time to hire your attorney. If you want an attorney and do not have the money to hire an attorney, you will need to fill out a financial questionnaire so that the proper person can determine whether or not to appoint an attorney to represent you. Now, if you want to represent yourself, that is, you want to waive your right to have an attorney. Waive your right. Waiving means give up your right. So if you want to give up your right to have an attorney, and if you want to represent yourself, then if you want to talk to the prosecutor about your case, if you want to try to work out a plea bargain agreement, you cannot do that. Or if you just want to talk to the prosecutor about your case, you cannot do that unless you first sign a written waiver of your right to be represented by an attorney. Now, the written waiver should be the second page, which is titled Waiver of Counsel for Purposes of Entering a Guilty Plea or Proceeding to Trial. I'll go over that after I finish going over this document. Now, you cannot speak to the prosecutor. As I meant, the prosecutor is the assistant district attorney. You cannot speak to that prosecutor about your case unless you first sign a written waiver of your right to be represented by an attorney. Now, be aware that there are dangers to self-representation. Waiving your right to an attorney and representing yourself may result in a worse outcome for you and your case, including the loss of significant legal rights and opportunities relating to military service, possession of a firearm, child custody, immigration status for non-citizens, and employment. If you choose to proceed without an attorney, that is, if you decide that you wanted to represent yourself, you may change your mind at any time, and then you can ask for the court to appoint an attorney to represent you. At the bottom of that document, in bold letters, it states defendant's choice. Mark initials next to only one choice. If your choice is to hire your own attorney, then you need to place your initials on the first line to the left. If you have already hired an attorney to represent you in your case, then you'll place your initials on the second line to the left and the name of the attorney on the line to the right. If your choice is you want to apply for a court-appointed attorney, then you can place your initials on the third line to the left. If you have already been appointed a court-appointed attorney to represent you in your case, then you'll place your initials on the fourth line to the left and the name of the attorney on the line to the right. If your choice is to represent yourself, that is to waive your right to have an attorney and to represent yourself, then you can place your initials on the fifth line to the left. Now, once you have finished initialing one of the 5 lines, then you will sign your name on the line that is titled defendant, and you will date it today's date, May 9th of 2023. And I'll give you an opportunity to do that right now. Yes.
I want to represent myself. Later on, I change my mind. I can't get an attorney or.
Read the last sentence. I just explained it. The last sentence. If you choose to proceed without an attorney, you may change your mind and may request counsel from the court. You can get your own attorney. Yeah, or you could see if you have or you can see whether or not you qualify for a court-appointed attorney. So it does not change anything. Okay, did that answer your question? Okay, now on the second page, for those of you who will be waiving your right to an attorney, that are only those people who will be waiving their right to attorney and representing themselves will have to read and sign the second page. The second page is titled Waiver of Counsel for Purposes of Entering a Guilty Plea or Proceeding to Trial. And it states, I have been advised of the nature and charges against me and the dangers and disadvantages of self-representation. My waiver is voluntarily and intelligently made. Furthermore, I have been advised this 9th day of May of 2023 by the county court at law number 2 of my right to representation by counsel in the case pending against me. I have been further advised that if I'm unable to afford counsel, one will be appointed for me free of charge. Understanding my right to have counsel appointed for me free of charge, if I'm not financially able to employ counsel, I wish to waive that right and request the court to proceed with my case without an attorney being appointed for me. I hereby waive my right to counsel. And if that is your choice, then you will sign your name above the word defendant, and you will also date it today's date above the word that is titled date. And again, today's date is May 9th of 2023. Now, as a defendant in a criminal case, you also have a right to have a trial by jury. And what a trial by jury is, when that young man is sitting in that area over there of the courtroom, we call that the jury box, selected to serve as jurors in your case. They will listen to all of the evidence, and after they listen to all of the evidence, they will deliberate. And after they deliberate, they will decide to find you either not guilty or guilty. You also have a right to waive your right to have a trial by jury. Waiving your right, again, means you're giving up your right to have a trial by jury. And by doing so, you will not be having a trial by jury. However, your case will come before the court or the judge in one of 3 ways. If you want a trial without a jury, then you'll be having a trial with a judge only. We call that a bench trial. The judge will listen to the evidence, and after listening to all of the evidence, the judge will decide to find you not guilty or guilty. Now, the other way the case can come before the judge is by way of an agreed plea bargain. A plea bargain is an agreement that you work out with the state to settle your case. An agreed plea bargain means that you and the state have reached an agreement to settle your case. Once that is done, then your case will come before the court or come before the judge, and the judge will decide whether or not the judge will follow the plea or not follow the plea. That is, whether the judge will accept the plea bargain agreement or reject the plea bargain agreement. Now, if the judge rejects the plea bargain agreement, then you have a right to take your plea back. Your agreement that you made with the state, you can take it back. We say that you have a right to withdraw your plea. Now, if the judge follows the plea bargain agreement or accepts the plea bargain agreement, if you decide within 30 days of your plea that you would like to appeal your case, that is, you like to have a higher court to review your case to see whether or not you have been wrongfully convicted or whether or not this court committed an error by convicting you, then you have to get permission from the judge to appeal your case. If the judge gives you the permission to appeal your case, then your case will be appealed to the Ninth Court of Appeals, which is right above us on the 3rd floor. They will review your case to see whether or not you've been wrongfully convicted or whether or not this court committed an error to convict you. Now, if they grant your appeal, that is, they say they find that the court either committed an error by convicting you or you've been wrongfully convicted, then they can either find you not guilty or they can send the case back down to this court and order this court to give you a whole new trial. If they deny your appeal or reject your appeal, deny your appeal, then you can appeal it to a higher court than the Ninth Court of Appeals. You can appeal it to the highest court in the highest criminal court in the state of Texas, and that is the Texas Court of Criminal Appeals, which is located in Austin, Texas. You would have to file what is referred to as a pro se petition for discretionary review. Pro se means you will be filing this review, this petition on your own without the assistance of an attorney. And the Court of Criminal Appeals, if they grant your petition, they can simply find you not guilty, or they can order this court to give you a whole new trial. Or if they deny your petition, then your conviction at that point will stand. Okay? Now, the other way that your case can come before the court, I mentioned that it can come before this court by way of a bench trial, by way of an agreed plea bargain agreement. The other way is by way of an unagreed plea bargain agreement. That is, you have been talking to the state or the prosecutor to try to settle your case, and you and the prosecutor have not been able to reach an agreement. Therefore, you want the judge or the court to assess the punishment in your case. We call that an unagreed plea bargain agreement. Now, you also have a right to have witnesses to come to court. That chair that has the microphone in front of it, we call that the witness stand. And what witnesses do, they can come to court and testify. They can testify for you or against you. If you're representing yourself, or if you have an attorney that's representing you, then witnesses can be asked questions. We call that either direct examination or cross-examination. And you can waive or give up your right to have witnesses to come to court. That simply means that you will not be calling witnesses in your case. It does not mean that the state will be not calling witnesses in your case, because they will be calling witnesses in your case. You also have a right, we call it a Fifth Amendment right against self-incrimination. And what that means is you have a right not to testify in your case. The state of Texas, the government, cannot force you to testify against yourself in your case. It's the Fifth Amendment right against self-incrimination. I know sometimes you may have heard it referred to as taking the fifth. That is, I'm not saying anything. Okay. And so the state, the government cannot force you to testify in your case. Now, you can waive your Fifth Amendment right against self-incrimination. And what that basically means is you can give up your Fifth Amendment right against self-incrimination if you choose to, and you can take the witness stand and testify in your case. You also have a right to have what we call, or what is referred to as, discovery. Discovery means you have a right to see the evidence that the state has against you. You have a right to see witness statements. You have a right to see videos, have access to audio recordings. You have a right to see documents or instruments that the state will be using as evidence in your case. Now, you also have a right to waive or give up your right to have discovery. Waiving your right to have discovery basically means you're saying that I don't want to have any access to the evidence that the state has in my case. Now, as a defendant in a criminal case, first of all, everyone that's here, you're here because you've been charged with an offense, a misdemeanor offense in this court, and you have been arrested and you are out of jail. Either we say you're out of jail on bond, you're either out of jail on a cash bond. If you cash bond, you mean you paid the full amount to get out of jail, or you're out of jail on a surety bond, which means that you had a bondsman to get you out of jail. You paid that bondsman a percentage of the total bond, or you're out of jail on what we call a PR bond. PR stands for personal recognizance. In essence, you didn't have to pay any money to get out of jail. You were released under your own personal recognizance. Now, every day that you spent in jail until you bonded out, you can get credit for every day toward your punishment. So, for example, let's say you were in jail 5 days and you bonded out. And let's say you and the state have agreed to you serving 5 days in jail as part of your punishment. Well, what that means is you would not have to serve 5 days in jail. Why? Because you've already served 5 days in jail. Therefore, you'll be given credit for the time that you have already served. Now, if the state is offering 7 days in jail, then that means that you would have to serve 2 more days in jail. Why? Because you're getting credit for the 5 days toward the 7, and you only have 2 left. Now, every day that you spent in jail is credited at $100 per day that will go toward your fine and your court costs. So, for example, if the state is offering you fine and court costs of $500 and you spent 5 days in jail, then you will not have to pay any money. Why? Because the 5 days in jail is $500 and you have already served 5 days in jail. And so the time that you served in jail has already paid it off. Therefore, the fine and court costs will be taxed and retired. Now, if they're offering $700, you did 5 days in jail, you would have to pay $200. Now, if you do not have the money to pay the $200, we can convert the fine and court costs, the balance, to community service. And every 1 hour of community service that you work, $12.50 will go toward your fine and court costs. So if you work 8 hours of community service, that's $100 that will go toward your fine and court costs. Now, Jefferson County has a program that is called pretrial diversion. If you've never been in trouble before, they will dismiss your case and you can get it wiped off your record. We call that expunge. It could be erased, deleted, or wiped off. That's what an expungement or expunction mean. So you can get it wiped off from your record. In order to qualify for the pretrial diversion, it has to be your first offense. It cannot be an offense involving unlawfully carrying a weapon or resisting arrest, and you have to have an attorney to assist you at making the application to the DA's office. And again, if you get into the program, the case is dismissed, you complete the program, you can get it erased, deleted, or wiped off from your criminal record. And we call that an expunction. Now, if you are a veteran of any one of the military services, any one of the military branches, any one of the branches of service, then they have a program. When I say they have a program, I'm talking about the district attorney's office. The district attorney's office has a program that is called Veterans Court, and it's for veterans only. With that program, you just merely have to be a veteran. If you get into the program, there's an application process. If you get into the program, you complete the program, case is dismissed, you can get it erased, deleted, or wiped off from your record. Now, this court has a program. The program that this court has is Community Safety Initiative, stands for CSI. The CSI program is a program that is designed to address the issue of recidivism. Recidivism is a word that basically means people commit crimes over and over. And how do we address it? We address it through the CSI program, the Community Safety Initiative. We have a partnership with agencies in our community. And with our partnerships, we are able to effectively reduce crime in Jefferson County. And the way the program works is as follows. Through the partnership that we have with the Spindletop Center and the gentleman that you see in the jury boxes from the Spindletop Center, he's going to come in a few minutes and let you know a little bit about their program. But the program that we have with the Spindletop Center, they will do what is called a private interview. They would do an assessment, and they can develop a treatment plan for either outpatient or inpatient service, or you could be referred to a facility that will be able to address your mental health needs. You can suffer from depression, anxiety, schizophrenia, bipolar, post-traumatic stress, whatever mental health issue you have, Spindletop will be able to address it. They have the facilities, they have the personnel and the expertise to address your mental health needs. If you have issues with drugs or alcohol, we have a partnership with Spindletop and the Spindletop has a program that is called ATAR. ATAR stands for Addiction, Treatment, and Recovery. And we also have a partnership with the local drug and alcohol board, and with the Drug and Alcohol Council, they have a program that is called OZAR. OZAR, like ATAR, is a drug and alcohol treatment program. With OZAR, it stands for Outreach, Screening, Assessment, and Referral. And with those programs, they'll be able to do a screening, do an assessment, and develop a treatment plan for either outpatient or inpatient to address your drug or alcohol needs. We also have a partnership with the Golden Triangle Empowerment Center, who has a partnership with Lamar University. And Lamar University has a program that is called CICE. CICE stands for Center for Innovation, Commercialization, and Entrepreneurship. It is a job training and a job placement program in the hotel industry, the shipping industry, and the chemical industry. Now, if you are looking for a job or if you're looking for a better job, they can provide you with that training in any one of the areas that you select, the hotel industry, the shipping industry, or the chemical industry, and they will assist you at getting a job in the area that you're trained in. If you have not graduated from high school and you would like to get your GED, CICE also has a program, it's a GED program, where they will be able to assist you at getting your graduate equivalency diploma. All of these programs that I just mentioned are free, does not cost you anything, does not cost our county anything. Only thing it requires of you is to take the time out from your schedule to address either your mental health needs, your drug and alcohol addictions, to get job training or to get education in the area to get your GED. And the reason why we have these programs is because, as I mentioned earlier, we would like to address the issue of recidivism, stop people from committing crimes. We believe that with these programs, we can produce productive people, and productive people do not commit crimes because they have too much to lose. This program was a program that I started in March of 2017, within 100 days of taking office. And in this court, we don't have court as usual, we have unusual court. And it's not because we're different, but it's because we're trying to make a difference of the lives of the individuals that come before this court. And we're also trying to make a difference in the county in which we live. In this court, we do not just give time, we take out time. We believe that we can make Jefferson County a safer place by not just arresting the problem, but by addressing the problem. And so if you interested in any one of the programs that I've just mentioned, just please let us know. We have brochures that can be given to you, and phone numbers and of people that you can contact to address any one of the needs that you have. Now, at this time, we're going to have Deputy Hinton come forward. He's one of the mental health officers here at the Jefferson County Sheriff's Office. He's also with Spindletop. Deputy Hinton.
Thank you, Your Honor. Good morning. My name is Steve Nick, and I'm a mental health deputy licensed by the state, petitioned by the sheriff's department. I'm here for one reason, because the judge has graciously invited me in his courtroom because every single person the judge found, statistics prove, is those who appear with legal issues commonly have mental health needs, substance use disorders, or sometimes just a lack of community resources to help you in your particular situation. And maybe this is your first time to be here, maybe it is your 10th time to be here, there's still hope. The program has the ability to change your life. But we're gonna need something from each of you all. This document that I've asked about, this is separate from the court documents. No one else will see this but me and another qualified mental health professional. What I need is for y'all to share that need with us so we can best figure out how to serve you in whatever situation you're in. We have no idea where you're at in your walk in life. So if you'll share that, if you'll write that, please, so we can make sure that we communicate either email, text, or call, so that we can follow up with you and best serve you. Also, I have a flyer for you. It tells you a little bit about the program. I'm going to give this to you when you leave. And it tells you some of the advantages of the program itself, but it also has a 1-800 number on there. Should you ever find yourself in a safe place, you can get help immediately. And when the court goes into recess here shortly, I'll be going out and visiting with y'all. I'll give you this flyer and I'll pick up those forms from you. And I'll ask any questions you may have. If you want to talk today, we can do that. The judge gave us the jury room back there. It's private. And we can speak today and kind of expedite. Thank you very much. Thank you, Your Honor.
Okay, thank you, Deputy Hinton. Now, ladies and gentlemen, the paperwork that you have in your hands on the tablet, that paperwork is going to be picked up by our court personnel. If you need any assistance to fill out your paperwork, we have our court personnel who's here, will be happy to assist you at filling out that paperwork. That's going to take some time for us to get the paperwork back from you and to go through the paperwork. And then once we do that, we're going to ask you to come up before the bench one at a time. And then once we ask you to come up at one at a time, you're either going to be in a category where your case is being reset to hire an attorney, or you'll be in a category to see if you qualify for a court-appointed attorney, or you'll be in the category to waive your right for an attorney to represent yourself. Now, as I mentioned earlier, it's going to take some time. If you need to use the restroom, there are some restrooms right outside the courtroom to the right in front of County Court at Law number 3 is the men's courtroom, and in front of, right across the hall, in front of the 172nd District Court is the female restroom or the women's restroom. So at this time, the court is being recessed, and it give our staff and you an opportunity to finish the paperwork. Court is in recess. Oh, and just, I need to mention this to you. Now, if you leave the courtroom to use the restroom, do not leave the courthouse, because if you leave the courthouse and do not come back in the courtroom, then a warrant can be issued for your arrest, because we're not finished. Okay? So at this time, the court will be in recess.